Hello ladies and gentlemen, I'm Philip Harris. I'm a partner in the construction department at Wright Hassall, and this is one of my several vlogs, and I'm just going to talk to you about subject to contract and what does it mean and what's its effect. And I'm looking at a definitive statement on this from the Court of Appeal in a case from 2020, which is Joanne Properties Limited against Moneything Capital Limited. So we all have a fair idea of what subject to contract means, but the court spells it out in this case. It says that the matters under discussion remain in negotiation, and they remain in negotiation until a formal contract is executed. So that means that neither party intends to be bound until a formal contract is made and executed, and each party reserves its right to withdraw, and that's an important point until the contract is signed on the dotted line and executed. So from that, what's the effect? Well, once negotiations have commenced on a subject to contract basis, ordinarily that condition is carried all the way through the negotiations, until a formal contract is executed. And this is the important bit, the fact that the parties have in fact reached agreement on all material terms will not suffice to establish the existence of a contract where the negotiations have been entered into on a subject to contract basis. So it may be complete, the parties may have reached a complete agreement on all of the matters they want to agree. It may be clear, they've reached agreement on all the matters, it's perfectly clear, there's no lack of certainty, there's no lack of completion in that sense, they've got everything together, but it's still not a contract until a binding contract, until the contract has been executed. So to have a binding contract in those subject to contract circumstances, there must be either entry into a formal contract on the basis that was to be agreed, as clear as that, entry into a formal contract, or there must be clear evidence that the subject to contract stipulation has been waived. In other words, it's been withdrawn. So you either execute the contract or you can show that the parties have waived that, they've set aside the subject to contract condition. And you can see that this can become a trap. So you've got two very senior business people running their business empires, let's call them Jack and Ted. The lawyers remind them before they kick off this negotiation, mark it subject to contract. So they do mark things subject to contract, but then Jack and Ted agree, everything, complete agreement, very clear. Jack thinks it's okay for him to go ahead. Now the agreement's been made. In a sense, the agreement has been made, but Ted comes back and says, oh no, we haven't got a formal agreement, we haven't signed on the dotted line, so there is no agreement. And it's that position that the Court of Appeal is endorsing. There is no agreement until the formal contract is signed or both parties have clearly shown, evidenced that they've waived this subject to contract stipulation. So something which is a sensible step to take in the negotiation process, the lawyers advise, mark everything subject to contract, can, at least for one of the parties, become a trap. Yes, so if you have any other questions, you can get in touch with us, wrighthassall.co.uk, or contact me, Philip Harris, on my email address on that site, or indeed my partner, Mike Hiscock, who looks after the non-contentious side of things and the drafting of contracts. Thank you very much.